Hi, this is Attorney Mizejewski, MJM Law Office here in Eugene, Oregon, and today we're going to be talking about whether you might want to take your case to trial if you've been arrested for driving under the influence of intoxicants, and what that process is going to look like if you're going to be successful and get an acquittal at that trial. So the main thing you need to consider if you are thinking about going to trial on your DUI is, do I have a valid, credible theory of defense? You know, that's what this is all about. Do you have a theory of defense that makes sense and is going to make sense to a jury of your peers? It's going to be sitting there on this jury panel, listening to the state or the DA give all their evidence against you, and listening to our case and deciding, you know, hey, maybe this person is not guilty of DUI. Now, a theory of defense on a DUI case is generally one of two things. Either I wasn't driving, it was somebody else, nobody saw me driving, the car was there, or I was not under the influence of alcohol or drugs at the time of driving. Now, this can include something like a subsequent drinking defense. Maybe I was driving, but then after getting home, I drank a bunch of liquor, and that's why now when I encounter the police, I am under the influence. So that's really going to depend on the witnesses involved in your case, any kind of evidence presented in your case. There might be surveillance, video evidence, and this is all things that we would get during the discovery process. That's that process that occurs after you're arraigned on your case, and then building up to these pre-trial hearings, kind of getting more information, doing our own investigation, understanding exactly what happened, and seeing how strong the case is against you, and whether or not the state can prove beyond a reasonable doubt that you were driving a motor vehicle while under the influence of alcohol. So, you know, you'd want to get an attorney on board early, as soon as possible, so we could start interviewing witnesses while the information is fresh in their mind, doing our investigation, and building towards a trial. Now, what does the trial process itself look like? Well, usually you'll be arraigned and then have a status hearing about 30 days out. If it's going to go to trial, we would usually set that for trial about 60 to 90 days out from that. And during the 3, 4, 5 month period, longer in a major felony case, we will be preparing. There's a lot of preparation that goes into getting an acquittal at a jury trial. When we do go in for trial, the first thing that'll happen is the court is going to bring in a group of people, maybe 30, 40 people, and we'll have an opportunity to decide who's going to be on our jury to a limited degree. We're going to be able to kick some people off that we don't think are fair or are biased. We can kick them off for cause, and other people we can just remove from the jury just because we get a bad feeling about it. Now, the size of your jury will depend on whether it's a misdemeanor or felony case. If it's a misdemeanor, there will be 6 people on the jury. If it's a felony, it'll be a 12-person jury. So that voir dire is critical. Say it's a cannabis DUI case. Well, you're gonna wanna talk to those people, make sure people are familiar with cannabis, how it affects you. Hopefully they've used cannabis, so that when the police are saying something like, you know, and they will say this, cannabis will impair you for up to 24 hours, you know, and it can lead to psychosis and all this crazy stuff that the police will be telling the people. You want the jury that's going to say, hey, wait a minute, you know, I've smoked marijuana with my friends and I've never seen somebody with a green coating on their tongue. You know, that's another thing the police will say to try to determine that you're guilty of a cannabis DUI. So the voir dire is critical. You also need to make sure, you know, you don't have people on Mothers Against Drunk Driving on the panel. You don't want people whose maybe brother was killed in a drunk driving accident, something like that. And so we really have a great opportunity to not only interview the people that will be on your jury, but to also start educating them about your theory of defense. And we'll start asking them, you know, hey, what do you think about prosecution of a cannabis DUI? Do you think the state of Oregon should have a blood test to see how much active THC is in a person's system, rather than this urine test that they use, you know, that only shows the metabolites and it's the waste bin of the body? There's absolutely no correlation between that UA and impairment at the time of driving. And so when we're questioning the potential jury, we're starting to develop our case and warm them up to what our theory of defense is. So we carry that theory of defense throughout this entire process. That's key. After we've landed on a jury, we pass the jury for cause, the jury is sworn in, and then it's time for opening statements. We'll make an opening statement that's going to be an outline of your case. It's kind of a roadmap. The prosecution will also make their opening statement of what they believe the facts are going to show. And so that's usually pretty brief. We're talking like 10 minutes, something like that. We'll each give an opening, kind of outline what we think the evidence is going to show. And then it's time for the state to present their case, and they're going to start putting on their witnesses. They're going to have the officer that arrested you, that made that traffic stop. If it's a drug case, they're going to have that drug recognition expert come in and testify about the process. They're going to have the lab technician come in and testify about the chain of custody of the urine sample, how they tested it, what they found, all of that. And this is also another great opportunity to forward our theory of defense through cross-examination. You've probably seen this on TV or in the movies where you get to really ask all kinds of questions to the people that are presenting evidence against you. And that is to help you ensure that you get a fair trial. And the more that we can have the state's witnesses give answers that support our theory of defense, the better. And when I do this, it's just yes or no. I really control what's being said there with simple yes or no responses. Don't let them go out into left field and start explaining things, so that we can have that when it comes time for our summation closing argument to say, hey, this officer said these things that were supporting our theory of defense, such as, the driving was good, you pulled over, you stopped at a safe place, you didn't stumble getting out of your car, all the things that you probably did right. And so that is the state's case. Then we have an opportunity to present our case. We'll present our witnesses. If we have any witnesses, and you as the defendant will have an opportunity to testify if you'd like to. And that's a tough decision you're going to make with your attorney. You only want to testify if there's a reason to. You're going to subject yourself to that cross-examination. But a lot of times that jury's going to want to hear from you. You have a right to remain silent and not talk, and we'll make that clear. The judge will make that clear. However, sometimes that jury kind of wants to hear your side of the story. So depending on how you might come across, we'll talk about whether that's going to make sense in your case to testify or not. After our case is done, the state would present any rebuttal case that they have, and then it's time for closing arguments. And this is when we really get to sum up, the entire case and be persuasive with the jury and explain to them, with demonstrative aids, whatever else we're using, why it is that the state did not prove beyond a reasonable doubt that you were driving under the influence of intoxicants on this date and time. And so that's going to be a longer closing argument, hearing maybe 30, 45 minutes, something like that. The state's going to go first, and then we'll get a chance to make our closing argument, and then the state will get another closing argument at the end. And then it's going to go out to the jury for deliberations, and that can take anywhere from 10 minutes up to several days, depending on how much evidence came in, how long the trial was, and if they have any questions and how clear everything was. And then finally, at some point, this jury is going to say, we have reached a verdict. They'll contact the judge through the bailiff, and we will come back to court. Usually we're on cell phone standby. And, that's the moment of truth. There's going to be a presiding juror, the jury foreperson, and they're going to come out, and they're going to hand a slip of paper to the judge, and it's going to basically say whether or not they believe that you are guilty or not guilty of this crime that you are being prosecuted for. And, that's an exciting time, and we love it when we get that not guilty verdict. That's an acquittal. That means that you walk right back out and you are free. Now, if you are convicted of that crime and the jury finds you guilty, then we would have to go back to court for what's called a sentencing hearing, and then we would talk about, what an appropriate sentence might be in your case. If you have a DUI case or any kind of other criminal defense case you're thinking about taking to trial, give us a call. This is Mizejewski, MJM Law Office. Thank you.